The broadcast is now starting. All attendees are in listen-only mode.
Hi, good afternoon. We'll be starting in a minute. All right, good afternoon. Thank you for joining our webinar this afternoon. The webinar is using CTAs to pursue GSA Schedule opportunities, the basics you need to know. My name is Catherine Flood. I'm counsel here at PilieroMazza, and I'm joined by my colleague Julia DeVito. We're both in the government contracts group here. PilieroMazza is a full-service law firm with offices in Washington, D.C. and Boulder, Colorado. We are most well known as a government contracting firm, and for 25 years we have helped our clients navigate the complexities of doing business with the federal government. We also provide a full range of legal services, including advice on corporate, labor and employment, SBA procurement programs, and litigation matters. Our clients value the diverse array of legal guidance they receive from us and our responsiveness as we guide their growth and secure their success. And in addition to the government contracts group that Julie and I practice in, we also have small business programs, labor and employment, business and corporate, and litigation. So now the main event. We'll get to an overview of what we're planning to discuss today. First, what is a CTA? I think that's a very good question because essentially there's very, very little guidance out there on that. We'll also be discussing the benefits of using a CTA, the differences between prime contractor and subcontractor and joint venture relationships, and CTAs. They're not the same thing. We're going to be discussing what it takes to be an eligible team member on a CTA. When you choose your team members, you have to think about team lead considerations. We'll also be discussing the utilization of team members' labor categories and rates. For the actual written agreement that you enter into the CTA document, there are certain key elements that you have to include. And then we'll be discussing at the end of the segment special concerns and issues that we've seen arise as we've been dealing with CTAs on GSA schedules. And then, of course, we'll have an opportunity for you to ask questions, and we welcome, and we'll try to answer as many as we can during the broadcast. So to start, what is a CTA? Well, technically it's defined as a contractor team arrangement. And this is a special term that's used for GSA schedules. It's different than the FAR 9.6 definition of contractor team arrangement. You might see that referenced in other procurements that are not GSA schedule opportunities. FAR Part 9.6 CTA. Those types of CTAs are generally speaking prime contractor and subcontractor relationships and joint ventures. A CTA is neither of those things. So it's different. It's very particular and special within the GSA universe. The authority for entering into CTAs is based on special ordering procedures found under FAR 8.403B. And in this particular FAR section, it says, GSA can allow special ordering through terms of a contractor's schedule contract. And if you go to your schedule contracts and you look at all the specific FAR clauses and then the GSA terms and conditions that are included in there, that would be clause I, FSS 40. And you'll see that if you go into your schedule contracts. And basically that clause says very little. It says that that schedule contractors can come together and form a CTA, and that they're all basically responsible for paying their own industrial funding fee, which really doesn't give you much guidance. So GSA hasn't promulgated regulations governing the CTA relationships or how contractors are supposed to enter into those. Basically, GSA has put out guidance on CTAs that's available on the GSA website. And they do say that they want the contractors to form a written agreement outlining the relationship. And there's specific elements that need to be included in that written agreement that we'll discuss later. In addition, CTAs can be formed for specific opportunities, or they can be created to create more of a general teaming relationship. You need to be careful, I think, because generally speaking, CTAs are used for small business set-aside opportunities. That's just what we've seen in general. If you form a CTA with one of your with another scheduled contractor, and it's an overarching CTA, and you haven't identified a specific opportunity, there might be a potential that that could be a long-standing relationship without that specific opportunity identified, and then we get into sometimes affiliation considerations. So that's just something to keep in mind as you go forward and form these relationships.
All right, so next we're going to talk about the benefits of using a CTA. Why would you want to use a CTA in the first place? So one of the main benefits is that multiple contractors that have GSA schedules can come together and each bringing their own labor categories or products that they hold on their individual GSA schedule contracts. Now, under a GSA schedule contract, you can only offer services or products that you have on your own contract. So if you want to pursue an opportunity that requires a labor category or a product that you don't have on your schedule, if you were in a CTA and your team member had that item or service on their schedule, then the CTA itself could go after that opportunity. And because you can sort of combine your strengths in terms of your labor categories or products on your schedule, that allows small businesses to team together to pursue larger opportunities or different opportunities that they would otherwise not be qualified for. So it just gives you another way to go after potential contracting opportunities using the CTA. And an important feature of the CTA is that all of the team members have what's called privity of contract with the ordering agency. So the agency that's placing the order will actually be in a contract with each CTA member. It's different from a prime and a subcontractor relationship that we'll talk about in a second, because all the CTA members have a contract directly with the agency as opposed to through the team lead or one prime contractor.
Right, and I think that's an important thing to keep in mind in these relationships, because sometimes we see team leads take on the role of prime contractor and kind of push their team members around a little bit in these arrangements, which is you can draw these CTA documents any way you want, but as a team member to a CTA, you do have privity of contract with the government, so there's no harm in pushing for your rights to be preserved.
So we've sort of alluded to this, but these CTAs are different from a prime contractor, subcontractor relationship and from a joint venture relationship. So with respect to a prime contractor and subcontractor relationship, a CTA is different because, as we mentioned, each team member is essentially a prime contractor. They have a contract with the government. And what is important about this and what makes it work is that each team member must have a GSA schedule contract. If it were just a prime contractor subcontractor relationship, the subcontractor would not necessarily have to have a GSA schedule contract because they don't have a contract directly with the government. But because the CTA is not a freestanding independent legal entity, and we'll talk about that a little bit later, the contract from the government is going to be with usually the team lead, just one of the CTA team members. Just so there's a contract between one entity, the government, and another entity, the team lead. Instead of having a subcontract, the CTA document is what governs the relationship between the CTA members. So that's another difference between subcontractor, prime contractor relationships and CTAs. And then that document would set out the responsibilities for each team member. And then team members themselves can have subcontractors, and they would be considered first-tier subcontractors because, again, the team members are all prime contractors. And so as long as the team members are just charging their own schedule rates rather than another CTA team member's rates, then it's not a problem to have subcontractors. Now, the second type of relationship that is often compared to the CTA is a joint venture. And a CTA is not a joint venture because most joint ventures are separate legal entities. Two or more companies will come together and form a new company in the form of the joint venture. And with a CTA, there is no new company formed. There's an agreement between the CTA members, but there's no separate legal entity. And then also, unlike a joint venture, each team member will still have to follow the terms of its terms and conditions of its own schedule contract. It must charge its own schedule rates, and it'll track its own schedule sales and pay its own industrial funding fee. So again, we're sort of hammering on this, but each CTA member is still a prime contractor operating under its own GSA schedule contract. And that would be different if it were a joint venture. The joint venture itself would have a scheduled contract or some other contract.
Right, and I think part of the reason why CTAs are attractive is because it's so difficult for joint ventures to get their own schedules. You know, that used to be a requirement for most of the schedules. I think IT 70 has recently updated this, but it used to be that the entity itself needed to have 2 years of past performance history and experience in order to get a scheduled contract. And for most joint ventures, they're new entities created for purpose of pursuing an individual opportunity, so that wouldn't necessarily work in that instance. And for small business joint ventures, they're specifically created to pursue individual opportunities. You know, they're a limited purpose entity meant to pursue a limited number of contracts and opportunities. So it doesn't make sense to create a JV and pursue a small business joint venture, pursue a schedule, which is a contract that can potentially last up to 20 years. So we're also going to talk about team member eligibility. So what does it take for you to participate as a CTA team member? Essentially, you just have to be, as Julia talked about earlier, you know, the privity of contract with the government. But that means that you have to have been otherwise eligible to bid that opportunity and be the prime contractor on the RFQ. So if the RFQ, the request for quotation, is released and it's a small business set-aside, in order to participate on the team, you have to be small under the NAICS code assigned to the RFQ. Or if it's an SDVOSB, you need to be SDVOSB, etc. So we've seen a lot of instances where, and I think because there's no regulations governing CTAs, it's almost a little bit of like a catch as catch can with regard to what we see happen officially, you know, with contracting agencies. Like, for example, Julia, I know we've had that case where, you know, you'll see a large business and a small business have come together and formed a CTA for a small business set aside, and somehow it gets awarded, and we have to, you know, be the kind of, you know, bad guys at that point and say, well, this should never have really been awarded in the first place as a CTA, because essentially, you know, every participant needs to meet the set aside designation for the RFQ. All work performed by the team members. I skipped ahead. But sometimes the RFQ will also allow the team members to utilize different schedules or SINs for a combined solution. And that's fine. Like sometimes you'll see an RFQ that says, you know, we want to combine elements of the professional engineering schedule and MOBIS, those SINs, not the, you know, under the professional services schedule. You'll have the PES SIN, PES, and then the MOBIS SIN, and they'll want certain labor categories and solutions that combine elements of those two SINs. That's fine. You can take one of your team members can have PES and the other can have MOBIS, and that would work as long as the RFQ allows for that.
All right, so we have mentioned that each CTA should have a team lead. So what goes into figuring out who would be the team lead and what does it mean to be a team lead. So GSA requires each CTA to have a team lead, and this is sort of for administrative purposes and to make it easier on the agency to have one point of contact, although they could contact any of the CTA members. But it's probably easier on the agency to just go with one, talk to one contractor rather than the entire team, because CTAs could have more than 2 members. And the team lead is also the entity under which the contract or the task order will be awarded. It'll be awarded under the team lead's DUNS number. So this can be a little confusing if you're the team member, because it's strange to have a prime contract where your name is not on it as the contractor, but in a CTA, that's just how it would work. And to make things easier, the CTA or the team lead can manage ordering among the team members to make sure that you are meeting the ordering agency's needs and actually complying with the terms of your task order. So, excuse me, the team lead, you might have an ordering agreement amongst the parties just to document how the work will be distributed, or that could be set out in your contractor teaming arrangement, CTA agreement that we'll talk about later. And it's important to consider the mechanics of the ordering procedures when you are using a CTA to enter into a blanket purchase agreement under which further orders will be issued. So you're pursuing a BPA, but you don't know exactly what orders will be issued under it. You want to figure out in advance how the orders will be performed so that you can easily and quickly perform them once an agency actually awards those orders to the CTA. All right, so now let's talk about the CTA document. GSA in its guidance on its website has set out these terms that are the key elements of what a CTA document should contain. These are not the only elements that the document should contain, but GSA would like to see these in a CTA agreement if you're using a CTA to pursue a GSA schedule contract. So the first one is the duration of the agreement, and that's pretty basic, just how long the agreement will last, whether the agreement has option periods, and then if it does, how the options will work. What does it take to exercise them? What are the circumstances under which the option would be exercised? That kind of thing. Again, we've mentioned the team leader, and the CTA document should identify who is the team lead, the responsibilities of the team leader, what that team lead will actually do under the CTA. And then if the team lead will change at any point, for example, if you know your team lead only wants to be a team lead for a year, your CTA document would explain how long the existing team lead will stay the team lead, and then what will happen, how procedurally you will change the team lead. Will you notify the government, that sort of thing. And then aside from the team leader, you'll have the team members, and we sort of, I think, have referred to participants in a CTA as team members, but in this context, this would be everyone else besides the team lead. So the CTA document should identify all of the team members. It'll identify what the team members will do and then what they cannot do. What limitations are there on their responsibilities? For example, if they can't submit a proposal on behalf of the CTA without talking to other members, something like that. You would want to specify that in your CTA document. For communications, the CTA document should include points of contact for each team member. And this would serve 2 purposes. So in general, in any kind of contractual relationship, you would want to include points of contact for each party, so it's easier for the other party to reach out to you and communicate with you. But also this is so the government knows who to communicate with for each CTA member, because again, as we've said, each CTA member is a prime contractor, so the government has the authority and the right to reach directly out to CTA members and talk to them rather than going through just the team lead. The next type provision that you should include in your CTA document is invoicing and payments, and this would just set out the responsibilities among the parties for invoicing and payment, including the method of payment, whether it'll be by check or electronically, however the CTA members prefer. And then the GSA also would like CTAs to acknowledge that the team members, without government involvement, would resolve any dispute involving the distribution of payment between the team leader and the team member. So the government wants to make it clear that it will not be involved in your invoicing disputes among the team members.
They want no part of that.
Yeah, they want no part of that. All right, so the next provision is the legal relationship. And as we've mentioned, the CTA is not a freestanding legal entity, and so the agreement should make clear that it doesn't create a joint venture or a subsidiary or any other sort of relationship between the parties or the CTA members other than just being in the CTA. The delivery responsibility, that provision should specify who is responsible for a particular part of the project, just so it's clear who will have responsibility for delivering on the work that's required. So again, that just makes it easy to make sure that when you have multiple members in the CTA, everyone is clear of who's doing what in performing the order. Confidential information, this is just to identify any proprietary or confidential information of the CTA members and then explain how that information and any related rights will be managed. This is a good sort of provision to have in any kind of agreement if you're going to be sharing confidential or proprietary information, and I would imagine that pricing and other things like that will be shared between the CTA members, so you want to make sure you figure that out in advance. The identification of parties, that is very straightforward. You just want to identify all the members, and the agreement should be signed by each CTA member. It must include the GSA schedule, contract number of each member, and then you want to include the name and address of the ordering activity. And this is, like Katie was mentioning earlier, if you have identified a specific opportunity that you're pursuing as a CTA, then you would want to include the information for that agency in there. And then GSA also wants the agreement to state that it is solely between the team members, that the government is not a party of the CTA document. And so conflicting terms. So if the agreement should state that it does not conflict with the terms and conditions of a member's schedule contract, the GSA schedule contract will always be controlling, even if some other agreement is containing conflicting terms. So it's just good to spell that out in the CTA document. And then specific team activities. So the document should specify what activities will be incorporated into the team arrangement, and then identify who is responsible for each identified activity. So this could be putting together proposals, talking to the government, invoicing, all of that sort of information. You want that specified in the CTA document ahead of time so there's no confusion later.
In addition, the CTA should include a provision with regard to independent contractors, stating that all team members remain independent contractors responsible for their own employees. And again, that's just to reiterate that each team member is in privity of contract with the government, has their own schedule contract, the terms and conditions of that schedule contract apply, and they're not combining to form some new legal entity to pursue the work. CTA should also include a provision with regard to replacement of team members. This addresses the circumstances and procedures for replacement of the team members, including the team leader, and should state that the team must obtain the approval of the ordering activity prior to replacing any team member after receipt of an order. Oftentimes, this is a confusing requirement to a lot of our clients because, when you enter into a CTA, there's going to be a team lead, and usually, as Julie was talking about earlier, the team lead, the actual order is issued under the name of the team lead and their DUNS number, etc. So oftentimes our clients will ask us, well, how can we replace the team lead if the team lead is the one who has the contract, right? Seems silly, but we need to address it in the actual document itself, or otherwise, GSA wants to see that in there. Additionally, you should include a clause with regard to performance evaluation. Um, this should, and this is a new provision that we've just recently seen updated in the GSA's guidance with regard to who GSA wants to see, who the contractors would like to for the government to evaluate performance under CPARs. So that's a good consideration because you both are all team members are considered prime contractors with the government, and CPARs is the main way that you track and record your performance history under contracts. I've been thinking through ways we can do this. It shouldn't necessarily just be the team lead who gets to include the CPARs information. I think if you have, for example, like a CTA where you're pursuing a BPA schedule and you trade back and forth who's going to be the team lead for individual task orders awarded under the BPA, that might be the way that you would want to also record the CPARs information. If one team member is doing the most of the work under a particular order, it would make sense for that team member to get the CPARs information. Additionally, this is just a little bit unrelated to CPARs, but when GSA records the information with regard to the CTA award in the Federal Procurement Data System, FPDS, GSA has been instructs ordering agencies to note that the award was made to whichever team member received the preponderance of the revenues under the CTA arrangement. So I don't know if ordering agencies are going to be guided by that instruction when they're filling out CPARs. It remains unclear. Additionally, the CTA document needs to include a section with regard reporting of sales and industrial funding fee payment responsibilities. And again, that just goes to each CTA team member is truly treated like a prime contractor. So they're going to be responsible for paying their own IFF, and they're also supposed to track their own sales. In addition, the CTA should include a section with regard to pricing. It should specify unit prices or hourly rates and how pricing is calculated. It should list the supplies and services in pricing, include any team lead task pricing, task management pricing if applicable. So that's the team lead fee that we sometimes see in these agreements where the team lead will charge, let's say, like a 3% fee on any work that's been invoiced under the team member schedule as quote unquote the management fee for managing the CTA. That's permissible. In addition, all prices charged to the buyer must be at or below the applicable contractor's schedule contract prices. That's obviously very important. And then also, too, you want to explain how any order incentives or fees will be divided within the team if applicable. The CTA document should also discuss liabilities, which documents each team member's responsibilities and performance requirements so that liability is clearly established. This goes back to warranties. If there's specific warranties in your CTAs, in your schedule contract, generally speaking, GSA wants you to include those warranties in the CTA as well, that each team member is responsible for their own warranties. And then probably maybe one of the more important provisions in the document, ordering procedures. GSA wants the CTA document itself to describe how the team will handle processing orders from the government. And this is where you have a lot of flexibility in the document to discuss, well, okay, let's say, if it's a BPA and a task order RFQ comes out, if it discusses statement of work sections XYZ, then team member 1 will be the one who's the team lead for that order, et cetera, et cetera. So with all of that background, this is the basics, right? These are the basics of entering into a CTA relationship. There's no regulations or additional authority beyond the guidance that GSA has put out on its website, which we've just discussed. So with that being said, we wanted to highlight some special concerns and issues that we've seen pop up in our practice that people call us about. So the first one that I would note is that, all those clauses that we just, discussed in some detail that might have seemed exhaustive to you, but really that's just a start, I think. When you're forming these documents, you want to make sure that you include the typical provisions that you would normally see in a subcontract, for example, or I know we harped on before that these are not subcontracts, these are not joint ventures. All that being said, no one is going to be the perfect teaming partner, and these are teaming relationships. So you want to make sure that you've spelled out or that you've handled in your CTA document how you're going to handle disputes, indemnification provisions, termination provisions, all those general clauses that you'd like to see in your general agreements.
And another issue, we've talked about how each team member has privity of contract with the ordering agency, but that can create a little bit of confusion on the part of the agency. Some ordering agencies treat the CTA team as more of a prime contractor-subcontractor relationship. They will only deal with the team lead, and they will treat the other team members as if they were subcontractors. So if you're the team member and not the team lead, you need to make sure that the CTA agreement protects your rights, makes clear that you are a prime contractor, and then you should assert your rights. You have the right to talk to the agency. So if the agency is refusing to talk to you, you need to educate them on how a CTA works, because you, as a team member, are a prime contractor.
And we've seen that happen. Yeah.
Yeah. So some of it, it's not that the agency's just ignoring the existence of the CTA, it's they don't understand how it works. So with many things that we deal with here, education of the government is an important step that will hopefully smooth out the relationship going forward. Additionally, Katie talked about CPARs and making sure, if you can, that the CPAR is attributed to you if you are the team member as opposed to just the team lead. And if your CTA is set up so team members are alternating performance in the lead capacity on an order-by-order basis, for example, you want to figure out a way to communicate with the agency to make sure the CPARs are attributed to the right member. If the team lead is not involved in performance at all on a order and you want to get credit for that work. Or if the team lead or somebody else, another team member, screws something up, I don't know if you want that attributed to you if you are the team lead. So you got to figure out how that will work with your CTA members and then the agency that you're working with. And then keep in mind, we've talked about this, that GSA's guidance is only that, it's guidance. So this sort of speaks to the issue of educating the agency personnel that you need to explain to them if you're in have an issue with privity of contract, if you're a team member, that you might need to explain to them what they should be doing. And unfortunately, the only guidance you can point to is the GSA's guidance on their website, but that still is something.
Additionally, another issue that we see come up is invoicing considerations, and Julia mentioned this earlier when we were talking about the elements of the CTA document, that you do have to specify how you're going to invoice the government for payment under the CTA work. And GSA has recommended that even though the team lead can invoice for all the work performed by the CTA team, GSA recommends that each team member be paid separately and individually by the ordering agency. And to tell you the truth, that's the solution that I think is most appropriate, because there is, not that there's an open question, I think it's mainly been settled, but there is kind of an issue with regard to, well, okay, these are CTAs, they're not prime contractor-subcontractor relationships, they're not JVs. If you're a small business, how do you apportion the revenue that you receive under these CTA teaming relationships towards your size purposes. If you're the team lead and you're a small business, you don't necessarily want to be taking on all the revenue from your team members that your team member is performing. That's their money, that's their scheduled contract, they're the ones who are charging it. We think based on the privity of contract that each team member maintains with the government, it's not appropriate for the team lead to take on those revenues. But if this ever becomes an issue with, for example, the SBA during a size protest, if you've invoiced the government, you, the team lead, have invoiced the government and received payment from the government for work that your team member has performed under a CTA, there's nothing in SBA's regulations that would say take that revenue out. So of your own personal size calculations. So I think it's just cleaner and easier if each CTA team member invoices, at least receives payment separately from the government. That was kind of like a little bit of a spiel. But
so on a sort of related note, team members can only perform under their own schedule contracts, labor categories, and rates. We hear this a lot, that CTA members will try to mix and match and share labor categories if one of them has a more appropriate labor category or better rates for the order they're going after or performing. Team member A will try to use team member B's labor category or rates. And even though the team can come together and each team brings its own labor categories and rates, you cannot bill or perform under another company's labor categories or rates. Under a CTA, you are bound by your GSA schedule contract, and you can only perform under the GSA schedule labor categories or rates on your contract.
Right, that's because you're not like subcontractors. If you have a subcontractor, obviously they're going to be billing to the prime contractors, GSA schedule, labor categories, and rates, and that's perfectly fine. But CTA team members are not subcontractors.
Right.
And then finally, there is a question of who is going to be the team lead for individual task orders, and we've kind of referenced this throughout the webinar. That you can trade back and forth who's going to be the team lead. Sometimes RFQs will specifically say that in their instructions. If it's, for example, for a BPA, an RFQ for a BPA, they'll say, describe who's going to be the team lead and for which specific orders. That goes back to the ordering procedures that we had discussed within the elements of the CTA document. You want to be very careful and descriptive when you're describing those ordering procedures, because I think this is where a lot of the tension can arise between team members. If you think that an order came out and it more appropriately fell, if a team member, for example, sees that an order came out and they believe that it more appropriately fell under the scope of work that they were assigned in the CTA document, but the team lead doesn't necessarily issue them that order to perform, you want to make the team member that you want to make sure that you have recourse under your CTA document to make that happen. And that brings us to the end of the webinar. We've received a number of questions, so we'd like to go through them. Well, we have you on the phone. We ended a little bit early, so I think we have time to address some of these questions.
Sure. So we got a question that says, if all members have privity with the government, will the government give CPARs on each team member? And we addressed this, that it's sort of unclear how procedurally that will work, but we think that you can request that an agency, if you are a team member, not the team lead, that the agency attribute the CPAR to you rather than the team lead or to both of you.
Yeah, and GSA has invited the parties to the CTA to state in their CTA agreements how they want that to be treated by the government.
All right, so we got a question that says, so even when forming a CTA, each contractor is only limited to using their rates and labor categories? That is correct. You can only perform under your own labor categories and rates. Okay. Veterans Affairs requires SDVOs to be set aside. My team partner is and I am not. Would I be allowed to perform work under CTA for the procurement?
And the answer to that would be, unfortunately, no. All team members to the CTA need to be otherwise eligible to compete for the RFQ as a prime contractor. So if it's an SDVOSB set aside and you're not SDVOSB, you wouldn't be otherwise eligible to compete. You could be a subcontractor to them, but then of course you get into the problem where maybe that SDVOSB doesn't have all of the necessary labor categories under their own schedule. But unfortunately that's just the reality.
Yes. Okay. Will an agency get credit for all set-aside codes of the team or just for the prime set-aside codes?
They should get credit for all set-aside codes of the team, and that's an interesting question because, I think we mentioned a little bit earlier, GSA has guidance that the award to the CTA should be recorded in FPDS based upon whichever team member receives the majority of the revenues under the CTA. When the agencies take credit for awards under FPDS, they're allowed to check however many socioeconomic credit buttons that contractor meets, even if it's not a set-aside. So if it's for example, a WSB set-aside, and the prime contractor also happens to be Hub Zone and 8A, then the agency can click 8A, Hub Zone, WSB in FPDS. So I think really it might just come down to who's receiving the majority of the revenues for that award, and then the agency can just check those boxes off in FPDS.
All right, so this is a question about an example we gave earlier where an RFQ might require capabilities of an engineering schedule combined with a MOBIS schedule. And in that example, would both or all entities of the CTA need to hold both an engineering or MOBIS schedule, or could a MOBIS schedule holder enter into a CTA with an engineering schedule holder to pursue the RFQ?
The latter.
Okay.
Right, well, depending on whatever the RFQ says. And interestingly, GSA has said too before that, if you, for example, happen to have MOBIS SINs and PES engineering schedule SINs, you can still bid on that work. It just wouldn't be a CTA. You don't form CTAs with yourself. But if you have all those SINs, you can bid it too.
Can a management fee be handled as a discount, or does it need to be a separate invoice?
I think that it would need to be clear with however you're treating it in your CTA document. I'm not sure what it would be discounting. You mean maybe I'd probably need to think about that a little bit. I'm not sure what it would be discounting. It would be an additional fee, and I think it would just need to be specified very clearly in your CTA document how it's being applied and charged.
I think that makes sense.
Yeah.
Okay, if the price can't be above the schedule rate and the prime has a subcontract handling fee, then does the teammate have to give a discount on their GSA rate equivalent or greater than the subcontract adder?
I think whatever the rate that you charge to the government would need to be below your scheduled price. So you can't apply, markups on your subcontractor rates that would tip you over the rate that you have on your schedule when you're submitting your invoice to the government. That's when you get in trouble with GSA during the audits of, for example, like a contractor assistance visit, where GSA would go through and see what rates you've been charging, and if they're higher than your schedule rates, then you're in trouble.
All right. Here's a hypothetical. Let's say there is an opportunity that involves two different schedules. You said that in the CTA, team members must have the schedule. So in the case of an opportunity across two or more schedules, does each team member have to have the multiple schedules, or can team A have one schedule and team B have another schedule?
No, the latter. Team A can have one schedule and Team B can have the other schedule, and come together, and that's how they're offering their different solutions to the government.
Can an agency issue task orders to different members, or must it go to the team lead? If the team lead changes based on the task order, will the agency change accordingly? So if you don't specify anything to the agency, they will most likely award the task order to the team lead. And the CTA document that we talked about earlier would usually be submitted with your proposal. So the government would know who all of the team members are and who the team lead is. If you specified something different, you ask them to award to another entity that's not the team lead, they probably would do it.
Right, but I think with the understanding that, right, like, so if a BPA is in the name of the team lead, I mean, it would be it'd be hard for the agency to issue an award under that to someone who doesn't hold the BPA.
Sure.
But it would be with the understanding that the team lead would be, and they would be interfacing with the team lead from the team member.
Okay, so do both CTA members must procure work under the same SIN?
That goes back to that example that I used with MOBIS and PEZ, that you can, if the RFQ is asking you to provide an innovative solution to the requirements and saying, okay, well, provide different types of labor categories that come under different SINs, then yes, you can do that. Usually it'll be clear from the terms of the RFQ whether you're able to do that. But I would say, generally speaking, most RFQs are released under specific SINs on eBuy. So GSA's eBuy. So if you receive, let's say the RFQ was released under MOBIS, the MOBIS SIN on eBuy, then hopefully one team member would have MOBIS to submit the quote to the government.
Okay, there was a question, why would a company want to use this? I assume this is the CTA format, and as we have talked about, it's a useful tool for companies that have different labor categories, or smaller companies. They can come together and be able to provide a solution to the government that they alone would not be able to provide. And then they would also all be prime contractors, which is advantageous in some circumstances. All right, skip one. So you were saying that a team member cannot also be a subcontractor to another team member. Why? Well, we weren't exactly saying that. It's more that in the CTA relationship, the team members are not subcontractors. One is not a subcontractor to the other because they are all prime contractors. But you could have a situation where, for whatever reason, if you wanted to set it up this way, the companies are in a CTA, but then one is a subcontractor to the other.
Yeah, I think
it could work.
Yeah.
Okay. You mentioned that each CTA member is supposed to be eligible to bid alone on the procurement. Can this requirement be satisfied, for example, in a small business set-aside situation, if the CTA states that the small business team member will always maintain 51% or more of the total contract value? The answer is no, because each CTA member is a prime contractor, so that means they each have to be eligible for whatever kind of set-aside it is. So in that circumstance, if the other company is not a small business, even if it's performing less than 50% of the contract, it's still, the CTA itself would not be eligible.
And I would see why you'd want to do that, because you really just want to get to those labor categories, I'm sure, that the large business would be bringing to the table. But it just doesn't work in a CTA arrangement. And just to piggyback on Julia's point, all work performed by the CTA team members counts towards the limitations on subcontracting. So if your team member A performs 30% and team member B also performs 30%, and then the other 40% is subcontracted out, that team still meets the limitations on subcontracting. And that's why it's important that all team members meet the socioeconomic designation of the procurement.
Exactly. Have you seen a standard team lead administrative handling fee?
It's really not standard, and it's not necessary at all. Unless that the team lead is bringing more to the table in their management of the relationship. It's basically a way to kind of bake in markups that you would normally see in a subcontractor relationship. It's kind of like the same concept in the team, that the team lead is essentially acting as the prime, and therefore needs to be able to mark up, quote unquote, the team members' rates. There really isn't a standard figure. The norm I've seen is 2 to 3%.
All right. Can the team lead submit one invoice and have the customer remit payment directly to each team member, or does each team member need to invoice separately? And if one invoice is acceptable with separate payments, how would you recommend the invoice be set up to accomplish separate payment?
It would, yes. So you can submit one invoice, and then there would be separate payments, because the separate payments would be to each what has been invoiced under each scheduled contract. So you would probably need to identify, 45 hours at team member X's labor category Y, and then if it's team member X's labor category, then the government should issue the payment directly to team member X.
But you could also do separate invoices if for some reason that doesn't work.
Yeah. Just make sure you specify in your document. And that's why it's important when you submit your proposal, it's not expressly clear. I mean, because these are just, GSA has just issued guidance. And then there's not really a regulatory requirement. It's not really clear whether or not you're supposed to submit your CTA as part of your proposal. We recommend that you do, just so that the ordering agency can see this and approve it, and then there's no question later down the road.
Mm-hmm. What does it mean for a CTA member not to perform under another member's labor category under a fixed price contract? So this comes into play when you're pricing the order under GSA Schedule or GSA Schedule order for services. You need to specify what labor categories you're using, and so if it should be clear that the entity that's going to perform is proposing its own labor categories.
Right.
Do you recommend having the CTA signed prior to proposal submission? Yes, we recommend that. Are CTAs used for bidding GSA BPAs, or can they be used for bidding IDIQ vehicles with other agencies, such as NIH vehicles?
No, this is really strictly within the GSA schedules universe. These and it's a weird hybrid of subcontractor and joint venture principles, I think, and it's really been created just so you can pursue GSA schedule opportunities. But no, that goes to the point that we were speaking about before, that these are not FAR 9.6 arrangements. It's in and of itself, and it's very specific to GSA.
Can a CTA member also serve as a subcontractor to another team member on an effort? We talked about that earlier, that we think you could do it under the order awarded to the CTA, and then you could also do it on another contract that your CTA member has. Does the CTA have to be submitted to the ordering agency? Yes, we would recommend that you submit it with your proposal, and sometimes the RFQ would require it. It would say if you are submitting as a CTA, you have to include your CTA agreement.
And then it's just to I'm sure, when you're reviewing your RFQs, also sometimes the ordering agencies have their own requirements that they want to see in the CTA. So you always need to review that very carefully.
Does the U.S. government view CTAs as a higher or lower risk than joint ventures or traditional prime subcontractor teams?
I think it's different. I think it's something That's not standard, but I think that they're used so often that I don't know if ordering activities have assigned them a higher level of risk. They're accepted. I think there's just some confusion about what type of relationship is being created here.
If we are the team lead and we are invoicing the government for the whole team, then is all of the revenue for the CTA attributed to us as the team lead? This is something we touched on earlier. If you just go by the strict SBA rules of determining size and the money is paid by the government to the team lead, then the team lead technically would be responsible or would have to count all of that revenue for its size purposes. But that is why we would recommend, if you can structure it this way, having the government pay the team members directly so that money is not flowing through the team lead.
Yeah, well, I'd almost even say too that like it would be like an open question in that it wouldn't be maybe necessarily directly attributed, but you're avoiding the question, I think, if you do it individually, if you invoice and or get paid at least individually.
If you're a CTA member, not the CTA lead, do you still get credit for the GSA contract win? Each GSA contract holder must show their winning work under their schedule each year.
Yes, right, because you're tracking. One of the requirements is for you to track and report your own sales under the labor categories under the CTA, and then pay your own IFF. So, absolutely, right?
Yeah. Is there any restriction to whether not non-set-aside / special interest groups can team up with ones who are? I think the question is asking whether other than small businesses can team up with small businesses, and the only restriction would be whether the order or BPA is set aside for small businesses, because then the non-small business CTA members would disqualify the whole CTA. So the CTA does not allow for pass-through.
Is that, I think that might have been maybe the question with regard to the management fee being a markup. Is that, I'm not otherwise, essentially you just have to invoice the government under the terms and conditions of your own scheduled contract, right? And make sure that you're applying the labor rates and labor categories in your own scheduled contract. So however normally you invoice the government under your scheduled contracts, it's applicable here too. It's just that each team member needs to make sure that they're following their own contract terms and conditions and invoicing under their own contracts terms and conditions.
All right, I think we have time for one more question. So for small business set-asides, any special considerations regarding affiliation, such as common control or common ownership?
I would say yes. I mean, this is an interesting point because SBA's regulations don't account for CTAs. They don't discuss them. So in the affiliation regulations, for example, there's discussion of subprime and subcontractor relationships and affiliation that occurs through joint ventures. It really does not discuss CTAs. Generally speaking, CTAs, as we keep saying over and over again, you're in privity of contract with the government, and you're each considered a prime contractor. So, and then, hopefully you're invoicing and charging and performing under your own scheduled labor categories and your own scheduled rates. So, and then you have those provisions, in your CTA document that you're each an independent contractor. So hopefully there's that demarcation between the two of you, so you're not really becoming affiliates for this particular opportunity. All that being said, there is the, if you have a CTA document, is just one more contract that you have with another entity. So if you already have entered into 5 or 6 subcontracts with a particular entity, and now you're forming a CTA, at some point, I think that SBA would include that in looking at how many agreements that you've had together in an affiliation analysis. All right. Well, thank you very much. We've appreciated all these questions. It's definitely a new and interesting area of law, and hopefully we've answered and addressed some of your questions. Thank you very much for joining us this afternoon, and have a good rest of the day.